four criteria in order for an individual or a couple to qualify for Medicaid. The first criteria is they have to be a resident of New York. The second criteria is they have to be what's known as DAB, disabled, aged, or blind. The third criteria is their income has to be within the Medicaid allowable. And the fourth criteria is that their assets have to be within the Medicaid allowable. So the first criteria, they have to be a resident of New York. That's pretty self-explanatory. The person has to live within New York State. Fortunately, there's no length of period of time that they'd have to live here. A person can move here from another state a week ago, 2 weeks ago, and if their intent is to establish residency in New York and to live in New York, they can qualify for Medicaid. There's no minimum amount of time that they have to live here. The second criteria is they have to be either disabled, aged, or blind. So aged is 65 and older. Disabled and blind means that either Social Security has already determined that this client is disabled if they're under 65, or we can submit disability paperwork with the Medicaid application, and Medicaid will determine if the individual is disabled for their purposes. And generally, what it means to be disabled is unable to work, to be employed and have substantial gainful activity, which typically means to work and earn more than approximately $1,300 a month. So if a client is 65 and older, they can qualify for Medicaid. If they're under 65, they have to be either disabled or blind. And again, if they are already receiving Social Security disability, that is sufficient evidence that they've already been determined disabled. If they have not already been determined disabled, we can submit disability paperwork with their Medicaid application. Their doctor will have to complete a form. There's some additional forms that need to be filled out, but Medicaid will then make a determination if they qualify for disabled under their criteria. Okay. Now, the two main financial criteria for qualifying for Medicaid are income and assets. So right now, as of 2023, the Medicaid income limit for an individual is $1,697. And for a couple, it's $2,288. Now, that was a huge increase from the previous year, from 2022, when the limits were $954 for an individual and $1,387 for a couple. So many people that didn't qualify for Medicaid in the past now are eligible for Medicaid because of this jump in the income limits. Now, I mentioned that these are the numbers for 2023. We have not yet received the updated numbers for 2024. We expect to receive them sometime soon, but we're projecting that those will be approximately $1,750 in income for an individual and about $2,370 for a couple. So not as big of an increase as we had from 2022 to 2023, but still a small increase that may help some individuals qualify that didn't qualify previously. Having said that, even if an individual's income or a couple's income is above the Medicaid allowable, they can still qualify for Medicaid in a couple of different ways. So let's say, for example, an individual's income right now is about $1,725. So that puts them about $28 above the Medicaid allowable. So that doesn't automatically disqualify them for Medicaid. What it means is Medicaid will approve their application and say that they have a spend down or a surplus of $28. So the individual can pay that $28 to Medicaid, and by doing that, Medicaid no longer counts it as part of their income, and now their income is considered to be within the $1,697 allowable. So if a client's income is a little bit above the Medicaid allowable, it makes sense for them to pay that money to Medicaid, and we recommend making a 6-month payment in advance, which I'll explain in a minute, but that will allow them to qualify for Medicaid even though technically their income is above the Medicaid allowable. So again, in our example, if the client's income is about $28 above the Medicaid allowable, we would recommend them making a 6-month payment of about $150, $160 to Medicaid. That would activate their Medicaid for long-term care, and they would be eligible for full Medicaid services without having, without worrying about not meeting the income limit. Now, the reason why we recommend making a 6-month payment is because that will activate the Medicaid for long-term care. which should be the goal of somebody that wants to get home care services. So by making a 6-month payment, that enables the client to be eligible for MLTC services, for NHTD services, which again, Rene will discuss in further detail. A client can make a payment to activate their Medicaid month to month, but while that'll activate the Medicaid for things like going to the doctor and other services, it will not make them eligible for long-term home care services. So again, if a client's income is a little bit above the Medicaid allowable, we recommend them paying that difference 6 months at a time to Medicaid to activate the Medicaid for long-term care coverage. Okay, so that works if a client's income is slightly above the Medicaid allowable. But let's say a client between their Social Security and pension is getting $2,500 a month. So now they're about $800 above the Medicaid allowable. They're not going to want to just pay $800 to Medicaid each month and lose that money because that's a lot of money and people can't afford to give that up. They need that for their living expenses. So there is an option called a pooled income trust, which we can assist clients with setting up. And the way the pooled income trust works is instead of submitting that $800 to Medicaid each month, instead of paying that to Medicaid each month, the client can enroll in the pooled trust and they can send that $800 to the pooled trust each month. Now, doing so similarly allows Medicaid not to count that $800 as part of their Medicaid, as part of their income. And for Medicaid purposes, they're now within the allowable. Now, the difference is the pooled trust is run by a not-for-profit, and they will use that $800 that the client is depositing each month into the pooled trust account to pay expenses on the client's behalf. So the client can use that money to pay their rent bill, their utility bills, their grocery bills, etc. So it's a legal way for them to qualify for Medicaid while still getting to use that money for their expenses. So whereas if they just pay that money to Medicaid, that money is lost. If they put it into the pooled trust each month instead, they can still use that money for their expenses, for their day-to-day living expenses, and they're not losing that money, and they can still qualify for Medicaid. So it's the best of both worlds. Pooled trust charges typically the pooled trust charges a one-time enrollment fee of $250. They also charge a monthly fee of 10% of the surplus amount. So in our example, there would be an $80 monthly fee, 10% of $800. But basically for $80 a month, the client would be eligible for Medicaid and home care services. So the pooled trust is a wonderful program. We've been helping clients enroll in pooled trusts for many years now. It really works, wonderfully. A lot of people are skeptical initially about it, but it works. They get their bills paid on time, and they get to enroll in Medicaid. Just to backtrack for a second, the typical things that are counted as part of a client's income, almost all our clients have Social Security. Some have a pension. Some will have some kind of retirement annuity. Some will have an IRA distribution. So all of that money together gets added up and factored in when determining if the client has a spend down or if they qualify for Medicaid without a spend down. So all of their income gets combined, then subtracted from the $1,697, and that's their surplus amount if they have one. I'll let anyone jump in if they have any questions about the pooled trust or income.
There's a chat, Ed. Somebody messaged in the chat.
Okay, let me just take a look. Okay, so the pooled trust, there's many different pooled trusts. We use a company called KTS. We have a good relationship with them. They have excellent customer service. If we ever need a document from them, we get it immediately. So we use a company called Pooled Trust, and it's run by not-for-profit that's approved by Medicaid. There are other
what company?
KTS, Keep Them Safe Pooled Trust.
Right, I heard great things about them.
Yes. There are other pooled trusts out there. Some we've heard good things about, some not such good things. So you want to do a little research about the pooled trust company before you use them. Like I said, we recommend KTS, but there are about 15, 20, maybe more pooled trusts. They're all run by not-for-profits, and they are all approved by Medicaid. If you are enrolled in a pooled trust, can you make international transactions? I'm not sure what you mean by international transactions. If it's a legitimate bill for everyday living expenses, then I don't see why not. But if you want to post in the chat specifically what you're referring to, don't forget also the individual is allowed to keep $16.97 a month in income. So not all of their money is going into the pool trust each month. So any transactions that they don't want to use the pool trust for, they can still use, do from their regular bank account. It's only the money that's going into the pool trust that has to go specifically towards bills like rent, utilities, groceries, etc. The $16.97 that they're allowed to keep in their bank account, that money can be used however the client wants, and there's no limitations on it.
Ed, I'm going to jump in with a question. So
Sure.
if somebody wants to send money to a family member overseas, then that's not really something that you can be using the trust for. Am I right about that?
Correct. Yeah, the trust is not.
Ed, I'm sorry, you cut out for a moment there.
Ed, we can't hear you.
Can't hear.
Yeah, sorry, I was just getting a call. I don't know.
You can't just
okay.
you can't just ask the trust to send a payment for a birthday present, let's say.
Correct. The trust, the main types of things that the trust is not allowed to pay for are gifts to family members, or things that would be considered bad for the individual's health, like alcohol, tobacco, things like that. But pretty much any other bills that are in the client's name that are for their benefit can be used out of the trust. Like I said, typically it's rent, utilities, groceries, etc. So we'll work with the client to set up, what bills make sense for them to pay out of the trust and which other expenses they should be paying out of the money that they're allowed to keep each month. That's $16.97 in their own bank account. I think the individual clarified, if a person is trying to make a purchase from a vendor that is internationally, will the trust deny the payment? No, they won't necessarily deny the payment. Again, it depends specifically what the transaction is for. Let's say for some reason somebody wants to buy groceries from overseas or wants to buy electronics or furniture from overseas. I believe the trust would be able to pay that because that's a legitimate expense that's allowed under the trust. If the client wanted to give a gift internationally or wanted to buy something that was either bad for their health or something to that extent, then no, they wouldn't be able to pay it. But again, anything that they weren't allowed to pay out of the trust, they can use that $16.97 that they're allowed to keep to pay for any other expenses that they want that are not allowed to be paid out of the trust. Okay. Any other questions about the income or the pool trust? Of course, there'll be a question and answer session at the end as well. So if anything else you think of, feel free to post it on the chat and we'll get through it.
Ed, I have a question.
Sure.
You said that the pooled income trust charges 10%. Is that 10% of the amount going into the trust?
Correct. So yeah, that's the monthly amount based on what their surplus amount is. So again, in our example, if the client's income is $2,500 a month, they're putting approximately $800 a month into the pool trust. So they would pay $80 a month as their monthly fee. Now, just to clarify, the monthly fee is capped at $200. So if someone's income is $3,000 above the Medicaid allowable, they would still only pay the $200 monthly fee. It wouldn't be the full 10% of $300. It would be capped at $200. Similarly, there's a minimum of $30. So anybody with a surplus of $300 or less would still pay. They wouldn't pay 10%. They would pay a minimum monthly fee of $30. So it's basically 10%, but a minimum of 30 and capped at 200 as the monthly fee.
Ed, can you talk about the reason that we always encourage people to use the money in the trust every month rather than letting it accumulate?
Yes, absolutely. So, one of the, I guess, drawbacks of the pool trust, which there aren't many, is that if any money is left over in the trust when an individual passes away, that money kind of gets stuck there. It goes to the trust maintains it and they use it for their charitable purposes, or it goes to Medicaid. So as Rene mentioned, we do recommend that if the client has a large surplus, that they use as much of that each month as possible, because you don't want it building up in the trust and then having $5,000-$10,000 left over in the trust when the individual passes away. Unfortunately, it's unlike other trusts. It does not go to the next of kin. It does not go to the heirs. It kind of gets stuck there in the trust. For most individuals, that's not an issue, because if their surplus is $1,000, they usually have expenses that they're able to use it on a month-to-month basis. Sometimes if a client has a very large surplus, we've had clients with $10,000, $12,000 a month that they're putting into a pool trust. So then they have to get a little bit creative in using up all that money for their expenses. We tell family members or the client, if you see the money building up in the trust, go make a big purchase, go buy some new furniture, go buy electronics, perfectly legitimate, and that way you can use up the money in the pool trust. Another thing that the pool trust can be used for, a big expense, is if Medicaid approves an individual for 6 hours a day of home care services or 8 hours a day of home care services, but the client or the family wants to supplement that with private pay for additional hours, that's something else that the pool trust can be used for. And that's another good way, if they have a lot of money that's going into the pool trust each month, to use up that money on a month-to-month basis, so that any money that's left over doesn't get stuck in there and kind of lost.
And I think they can set aside funeral expenses also.
Correct. They can also set up a pre-need irrevocable funeral trust, and any funeral home would be aware of how to set that up. You can just mention that to them, and basically the client can pay on a monthly basis a portion of their funeral expenses, and the pool trust can pay. Then the pool trust can pay that expense from the funds that the client is sending them. So there are many different ways for a client to use up money in a pool trust. Again, for most of our clients, it's not an issue between the rent and utilities and other bills. It's usually pretty simple. But again, if you have a high income individual, you might have to get a little creative with some of the ways to spend the money. But for the most part, almost everyone's able to do it. Okay. So moving along to the asset test. So right now, till now, we were talking about income. That's something that a client gets on a monthly basis, Social Security, pension, etc. But now we're talking about assets, money in the bank, stocks, bonds, whole life insurance policies with a cash value. Right now, the limit for an individual is about $30,000 for 2023. And for a married couple, it's about $40,000. Again, that was a huge increase from 2022. When the numbers were about $16,000, $17,000 for an individual and about $24,000 for a couple. So again, that was a big increase, that allowed people that may have not qualified before to qualify now. Again, in 2024, we're expecting a slight increase to those numbers, maybe about $31,000 for an individual and about $42,000 for a couple. But we're not going to see the huge increase like we did see from 2022 to 2023. But we haven't received those numbers yet. As soon as we do, we'll share that information. One big exception to the asset rule, typically, again, assets consist of checking account, savings, CDs. If there's a life insurance policy under the client's name with a cash value, stocks, bonds, things of that nature. So Medicaid adds all those up and determines, what their total assets are. And if it's more than $30,000, then the client needs to do a little bit of work to qualify for Medicaid. Money in an IRA or a 401k that is in distribution mode does not count as an asset. So that's very important to note. Somebody can have an IRA with $200,000-$300,000 in it. As long as they're taking the required distribution from that IRA, then that IRA does not count as an asset, and it doesn't affect their qualification for Medicaid. They can have up to $30,000 in other assets, and that $200,000 in the IRA does not disqualify them. So that's very important to note. A lot of people think, I don't qualify, I have an IRA with X amount of dollars. But as long as they're taking the distribution, which we can explain to them what the correct distribution they should be taking is, then the IRA is completely exempt from Medicaid's calculations. Okay, so if a client's assets are below the allowable, that's great. They qualify for Medicaid. They don't need to do anything else. But what if a client has $100,000 in the bank between their checking, their savings? Maybe they have a life insurance policy with a cash value of $25,000. What do we do then? So the good news is right now, there is no look back period for community Medicaid. So that means a client can transfer assets this month and qualify for Medicaid the following month, and Medicaid will not ask them what happened with those assets that you transferred. They will qualify for Medicaid. So a client can have $100,000 in the bank today. We would recommend they speak with an elder care attorney who would probably assist with setting up a different kind of trust called an irrevocable trust. Sometimes it's called a Medicaid Asset Protection Trust. And the client can transfer the bulk of their assets into that irrevocable trust and qualify for Medicaid the following month. So if they have $100,000 in the bank, they would set up an irrevocable trust. They would create a new bank account under that irrevocable trust and transfer $75,000 into that new bank account under the irrevocable trust. Their assets would now be below the $30,000 in their name, and they would be eligible for Medicaid. And again, we recommend if a client's income assets are only slightly above the Medicaid allowable, they can just take some money out, give it to family. Like Rene said, they can prepay for a funeral expenses. In that case, we would recommend they just bring the assets down if they're only a little bit above the Medicaid allowable. If they're significantly above the Medicaid allowable, like I said, they would reach out to an elder care attorney. We work with several elder care attorneys that can assist. For a fee, of course, but they can then transfer the bulk of their assets into that trust. They would name who the trustees are, so it could be family member, friend, whoever they trust, and this way they can then become eligible for Medicaid. Like I mentioned, right now there is no look-back period for community Medicaid. However, New York State did pass a law a few years ago where they were supposed to institute a 2.5-year or 30-month look-back period for community Medicaid. Because of COVID, that has not been implemented yet. Right now, we're being told informally that the earliest it will be implemented, if at all, will be January 2025. So now is a good time if somebody's thinking about qualifying for Medicaid, and they do have assets, to definitely do the requisite planning to apply for Medicaid before that look-back period goes into effect, and that will make it much more difficult for an individual that has assets to transfer those assets and then qualify. Having said that, the look-back period has been postponed several times, because of COVID, and there is actually a bill in the Assembly to repeal it altogether and just go back to the no look-back period for community Medicaid. But right now, we're being informally told that it could go into effect January 1st, 2025. So to be safe, we're recommending to all our clients, do the necessary planning that you need to do to get your assets below the Medicaid allowable so that you can qualify without having to worry about the look-back period. Okay, any questions regarding assets, money in the bank?
There's a question in the box, Ed, in the chat box. There's
Okay.
2 questions. One I put out there, if you could
Yes.
discuss owning the home, but Hillary put a message in there also above me.
Okay. Yeah. I mean, you can go to our website. You can go to the KTS. I think somebody posted the KTS website. You can click on the KTS website. They'll have a discussion, in there, a video in there about the advantages of a pooled trust. There aren't really too many disadvantages.
Right. I don't see any.
But the common one we hear is, oh, I don't want anybody else controlling my money. I don't want anybody else paying my bills.
I do.
To that we tell the clients, look, you can try it for 1 or 2 months. There's no obligation to do it for the rest of your life. If you don't like the way it's working, they still direct the trust, tell them what bills they want paid. They still get to keep $1,697 a month in their own account that they can use however they want. So they're really not losing that much control or say over what's going on with their money. But like I said, some clients are a little bit hesitant about it. So we do tell them, try it out for a couple of months, see how you like it. For whatever reason you don't like it, you can stop at any point. Of course, they'll lose their Medicaid if they stop the pool trust. But if for whatever reason it's not working out the way they wanted, there's no obligation to do it in perpetuity. They can stop it at any point and go back to how things were. Having said that, none of our clients basically ever do that.
Right.
Once they see how the pool trust works, they see it operates exactly as we tell them it does, and that it allows them to qualify for Medicaid. They're pretty satisfied, and we haven't really had clients that back out of it after that point. Okay, let me see.
Ed, can I jump in? Can I just jump in?
Yes, sure,
now?
please.
If one does not have Medicaid, one is not going to qualify for long-term home health aides. So the only way around, if you want ongoing home care, like if you want a home health aide, you actually have to have Medicaid. So, that's the primary reason that most people really come to us and want to apply for Medicaid, because they need home health aides in the house.
Exactly. Any small, minor disadvantages or inconvenience of setting up the pool trust pale into comparison,
Right.
with the amount of benefits and services that the client's going to get. Especially since, if a client wants to pay privately for home care, that's going to run upwards of $3,000 a month in all likelihood. For the 10% monthly fee that the pool trust charges, they can basically have those same benefits for
Covered.
$100, $200 a month, whatever it is. And it's
And also, I think people have to change the way they think about these trusts. You're not giving away your money to Medicaid. You're actually just moving your money in a way that will then qualify you for so many services, primarily home care. Medicaid's not taking your money away pretty much. You're just moving
Exactly.
it, and then you're using it for bills.
Exactly. A lot of people are frustrated about the system. Oh, why do I have to do it like this? Why can't I just qualify? I tell them, listen, I don't make the rules, but these are the kind of legal ways, the loopholes, so to speak, that allow you to qualify for Medicaid. So you paid into the system just like everyone else. This is what you need to do to qualify, take advantage of the system, and get the benefits that you're entitled to. Okay, let me just see. Okay, a question here. Why is the pool trust approved by Medicaid? Does it not cost the government more money? So yeah, actually, it's a state-by-state decision. Some states allow the pool trust, some states don't. One of the great things about New York is when it comes to Medicaid, they're very lenient. They want people on community Medicaid. One of the reasons why is the thinking is if people get community Medicaid and get services at home, they won't need to go into a nursing home or a facility, which costs a lot more to Medicaid for them to pay. So I think the kind of the analysis done by New York State was that we'd rather have people stay at home, get services at home, and pay for that, rather than having a bunch of people go into a nursing home and then having Medicaid to pay for that, which is a lot more expensive. So I think that was kind of the rationale for why New York allows the pool trust. But like I said, New York tends to skew a little bit liberal. So it definitely is one of the better states when it comes to Medicaid, both in terms of qualifying and in the amount of services that an individual can get. We've spoken to a lot of individuals from Florida that surprisingly moved from Florida to New York. You would think Florida would be a great state for benefits and for Medicaid for elderly people, but the opposite is true. You're not going to get any, it's much more difficult to qualify for Medicaid in Florida, and the amount of services that they authorize are a lot less than in New York. So we do see a lot of people that go to Florida and come back to New York because of the benefits. Okay, so I see a question here. What can you spend the money in the Medicaid Asset Trust? So the Medicaid Asset Trust, as opposed to the pooled income trust, that's run by the trustees who the client names. Again, it could be family members, it could be friends, whoever they want. And the trustees have authority to pay expenses, again, for the client's behalf. I would tell them to speak to an elder care attorney to pin down the details. But basically, yes, they can use that money in that asset, in the Medicaid Asset Trust, to pay expenses, but it has to be authorized by the trustees. Let me see. Yes, I will discuss owning a home in a minute and its effect. Okay, how many hours of HHA services do you obtain with Medicaid? So that is really unknowable, and Rene can speak to it a little bit more. A nurse from Medicaid and from an MLTC will come out and do an evaluation, and based on that evaluation, they'll determine the number of hours. It really runs the gamut. It depends obviously on the client's age, their physical condition, their mental condition, all of their diagnoses, etc. So it's a complicated determination, and it's based on the evaluation of a nurse. There are some other programs which Rene will discuss, called like the NHTD waiver program, where a client can get additional hours sometimes if the hours provided by the MLTC are not sufficient. But that'll, I think, be discussed more in the next session.
So Ed, in case the look back does get approved, I think maybe we should talk about the need for people to set up Medicaid now, to set up a trust, even though they don't necessarily need the help just yet.
Exactly. Yeah, exactly. Like I mentioned, it's better to do the planning now, set up the trust now, get the Medicaid now, and not need it than need it. And now you're looking at a 2.5 year look back period where you're not going to be eligible for Medicaid because you transferred assets within the last 2 years. And now you're going to have to pay privately or wait, several months or a year or 2 years to qualify for Medicaid. So we can't stress it enough. Even though we don't know exactly when the look back period is going to go into effect, it doesn't hurt to do the Medicaid now. It doesn't hurt to do the planning now. And this way, the individual is locked in for the Medicaid. And even if they don't need the services yet, they'll be locked in and they won't have to worry about the rules, about the look back and the change. Okay, can you talk about setting that? Yeah, okay, so I talked about that. On this call with it, no, this presentation is about community Medicaid, so we won't be talking about institutional Medicaid. I will mention briefly that there is a 5-year look back period for institutional or nursing home Medicaid. That's been in effect for many years, so that law is not changing. So the rules are a little bit different about that, but we're not really getting much deeper into that right now.
Can you talk about, can you hear me?
Yes, I can hear you.
About, you just mentioned that you could set it up now, but not necessarily use it. So what does that mean? How do you set it up and what money goes in there or no money goes in? What does that mean?
Yeah, so for example, if a client has $100,000 in assets, they can set up the irrevocable trust now, transfer $75,000 now into that irrevocable trust. They can apply for Medicaid, get approved for Medicaid, and have the Medicaid dormant sitting there. They don't have to. People think that just because you have Medicaid means you have to take whatever services. No, you can have Medicaid. You can have it as a secondary insurance for your doctor's visits, for etc. But you don't need to set up home care services if you don't need it right now.
No, what I'm saying is for the pooled income trust, forget about the asset with the elder care attorney. Just the pooled interest trust, pooled income. You say you could set it up and not use it. So what does that mean? That we have to put the money in there now but not use it?
No. The important thing for the look back period is only the assets. So you can do the asset trust. You don't even need to set up the pooled trust yet until you need the Medicaid services. So you can set up the asset trust, transfer the assets, get below the $30,000 in assets, apply for Medicaid, have the Medicaid approved, let's say with a surplus of $800, and just let the Medicaid sit there approved but not active because you have a spend down of $800 or $1,000 or whatever the amount is.
But that has nothing to do with you. This is the other irrevocable trust. Yes?
Well, the irrevocable trust gets set up with the attorney, correct.
Right,
we don't set up irrevocable trust.
So I'm a little confused because you have a pooled income trust, that's you, where we pay $200 a month when we're ready to do it. And then
just to interrupt for a second. Sorry, just to interrupt for a second. We are not the pool trust. The pool trust is a separate company. It's a non-profit. We are not the pool trust either. We assist clients in setting up a pool trust, but we are not the pool trust company.
No, I understand that, but is that separate, that trust, from the irrevocable trust? Yes,
two separate trusts. The pool trust is for income, if a person's income is above the Medicaid allowable of $1,697. Right. And then there's an irrevocable trust for assets if their assets are above $30,000. Those two are two separate trusts, and a person might need both of those trusts. A person might need only one of those trusts, or a person might need neither of those trusts. If their income is above the Medicaid allowable, but their assets are below the Medicaid allowable, they'll need a pool trust, but not an irrevocable trust. Okay. If their assets are above $30,000, but their income is below $1,697, they might need an irrevocable trust for the assets, but not a pooled income trust. Okay. And the 30-month look back period, that applies to assets. So a client would need to set up an irrevocable trust, and if they wanted to get in before the look back period. So that's when we're talking about the 30-month look back period, we're talking about assets and an irrevocable trust.
Okay.
Angela just put a comment in there that's really very good. She said something like, it's instead of handing over the money to Medicaid, that's the purpose of a trust. So I would think, and if somebody has a very small surplus, it may not even make sense to set up a pooled income trust. Let's say they only are above 1697 by $100. They might want to say, the heck with the pooled trust, and just give the money, the $100 to Medicaid, and call it a day.
Exactly. And that's a determination we'll make with the client. You know, if the client is, let's say, you know, up to $50 above the Medicaid allowable,
Right.
for sure, it doesn't make sense to make the pool trust, to do a pool trust. If their income is $300 or more above the Medicaid allowable, it almost always makes sense to do the pool trust and not pay Medicaid. And then in between is kind of the gray area where we'll
Right.
discuss it with the client and we'll see, you know, what their preference is. You know, we have clients that set up pool trust for as low as $100 because, listen, even after the $30 monthly fee for the pool trust, they're still saving $70 a month. And for some people, that makes a big difference. They can't afford to lose that extra $70. They need it for their expenses. So they'll set up a pool trust and use that $70 to pay expenses. Other clients say, no, it's not worth it. They don't need that money really. And they can pay that to Medicaid and they're happy to do it that way. So it really depends on, you know, on the individual, and we'll discuss that with them. You know,
the assets, though, you said you can give it to a family member, but does that have to be under the irrevocable trust?
So it depends. So if, let's say, a client's assets are $35,000 and the Medicaid allowable is 30, so they're only $5,000 above the Medicaid allowable. By the time you're done paying a lawyer, you know, that $5,000 is going to be gone anyway. So in that case, we wouldn't recommend doing an irrevocable trust. We would just say, you know, take $5,000 out, you know, divvy it up among family.
Larger amount? Why can't we just give it to our children if it's a larger amount?
You can, and Medicaid is fine with that. The only thing is an attorney wouldn't recommend doing it that way because now you might have gift tax issues. You might have liability issues for your kids. Now they have an asset. If they get divorced, now that's an asset that they own that's subject to the. So for those other reasons, an attorney would recommend an irrevocable trust. But as far as Medicaid is concerned, is you can have $1 million in the bank. You can give $970,000 to your kid the next day, and the following month you can be eligible for Medicaid. So yes, you can do it like that.
As long as there's no look back.
As long as there's no look back, but an attorney wouldn't recommend doing it that way, nor would I, because there's other liability and tax issues.
I got it.
Okay. Okay. So Rene wanted us to talk about the home and how that counts towards assets. So basically, an individual can own a home with a value of about $1 million, an equity value of about $1 million, and qualify for Medicaid if they're living in that home. So we're not talking about a rental property or an investment property. We're talking about the home that the client lives in can have an equity value of up to $1 million, a little bit more than $1 million. We don't have the exact numbers for 2024 yet, but about $1 million, and they can qualify for Medicaid. Now, I say equity value, so that means that if the home is worth $1.5 million, but the client has a outstanding mortgage of $600,000 on that home, the equity value is $900,000, they still qualify for Medicaid. Even though the value of the home is worth more than $1 million, because there's a mortgage on it, that brings the equity value below the $1 million, and they can still qualify for Medicaid. Having said that, we would still recommend consulting with an elder care attorney and transferring the house out of the client's name prior to applying. And the reason for that is, even though Medicaid will approve the application, they will process the application with the house in the client's name, they do reserve the right to go after the estate once the individual passes and try to make a claim against the estate for monies and services that Medicaid laid out. So Medicaid will approve the application, even if the house is in the client's name. They will provide services for 10, 20 years, as long as the client lives. But then when the house passes through the client's estate, Medicaid could wake up and say, hey, you have a house that's worth $1 million that's passing through the estate. We laid out $100,000 in services over the years for the client's benefit. We want the estate to pay us back that $100,000 from the proceeds of the sale of that home. So that's the downside. That's why we recommend transferring the house out of the client's name. Again, you can consult with an elder care attorney, put the house into an irrevocable trust. There's a couple of other different options. There's something called the life estate that the client can transfer the house to a family member, but retain the right to live there. So there are a few different options if a client owns the home. We do recommend they transfer it out of their name prior to applying. Having said that, we have encountered clients that don't have any family, don't have anyone that they care to leave the house to. So they say, no, I don't care what happens to the house when I pass away. I don't care if Medicaid comes after the estate and takes some money. We don't want to transfer the house. We want to apply it for Medicaid as is. And that's perfectly legal, and they will get approved and they can get services.
But you said that you have to be living in the house. What if it's just a vacation house that you only live there for a couple of months?
Okay, so that's problematic because you're only entitled to own one homestead to qualify for Medicaid. Anything else now gets added to the asset limit of $30,000. So if you have a vacation home that's worth $100,000, $200,000, now that puts you over the $30,000 asset limit.
Right.
Again, that doesn't automatically disqualify an individual. It just means they have to do some work beforehand. Again, put that vacation home or that investment property into someone else's name or into the irrevocable trust, and then they can qualify for Medicaid. Okay, I want to just check the chat to see if there's any questions. No. Okay. Okay, that brings us basically to our last topic, which is spousal refusal. So it's a little bit of a complicated topic, and we won't go fully into it over here. But spousal refusal comes into play when there's a married couple and only one of them needs and wants Medicaid. So let's say, for example, we have a husband and a wife, and the husband is in bad shape and he needs Medicaid. And his income, monthly income, is only $1,500 a month. But her monthly income, let's say she's still working, or let's say she had a good pension, she had a good job, she has a big pension, and let's say her monthly income is $5,000 a month. So now, if we're applying just for him, his income is $1,500. He qualifies for Medicaid without needing a pooled trust. His income is within the $1,697 allowable. But of course, Medicaid is going to say, wait, you're a married couple. We're going to combine your income. His income is $1,500. The wife's income is $5,000. Now you have a combined income of $6,500. Now you don't qualify for Medicaid. The Medicaid income limit for a married couple is about $2,300. Now you're over $4,000 above the Medicaid allowable. So of course they have the option of doing a pooled trust for that $4,000 and having them both qualify for Medicaid. So that's one option. But let's say the wife says, you know what, I don't really want to do that. I don't want to do the pooled trust. I don't have $4,000 worth of bills to use that money on. Is there another way for just my husband to qualify? And the answer is yes. They can do something called a spousal refusal. So they would both sign a document called a spousal refusal. And basically what it's telling Medicaid is that the wife is refusing to make her income and assets available for her husband's care. And Medicaid will then process the application as if the husband is a single individual. So they'll only look at his income, they'll only look at his assets, and they will not count the wife's income and assets towards eligibility. He'll qualify for Medicaid and he'll get services. Everything sounds great. However, under spousal refusal, Medicaid reserves the right to go after the refusing spouse for contribution. So Medicaid will approve the application, they'll start providing services for the husband, but down the line, they may, and I emphasize the word may, come to the wife and say, hey, we laid out $25,000 worth of services for your husband. We want you to contribute towards that $5,000, $10,000, whatever the amount is. And as the legally responsible relative, as a spouse, she is technically on the hook for some of that money that Medicaid laid out for services. Having said that, in the 10 years I've been doing this, I've never seen them go after a spouse in a community Medicaid case, where a home care services case. Every attorney, elder care attorney I've spoken with, say they've never seen it in a community Medicaid case where they go after the refusing spouse. Having said that, it's something that is possible. Medicaid could become more aggressive at any point, and they could start to seek contribution from the refusing spouse. So it's something that we have to make the client aware of, that although there is a great benefit to it, there also is a drawback, and that is that Medicaid could theoretically go after the spouse for contribution. Having said that, even if they do, the maximum amount that they can go after is 25%. So if they laid out $20,000 worth of services, the most they can go after the spouse is for $5,000. So it's still a huge savings than if the client, had to pay privately for home care services. And again, we've never seen them go after the refusing spouse. But again, we have to let the client know, keep them informed, so that they're aware of their different options, and then they can make an informed decision about whether they want to do all the planning necessary so that both of the spouses qualify for Medicaid, or whether they're comfortable taking so-called chance with doing the spousal refusal and just applying for one of them. So that's basically how spousal refusal works. And the same thing is with the assets. So if the husband's assets are below $30,000, but the wife has $200,000 in the bank, she can do a spousal refusal. Medicaid will process the application, counting only the amount of money he has in the bank, and the wife's $200,000 will not count. And he'll be eligible for Medicaid.
It's easy to get a divorce, but still live together as a married couple, but legally get a divorce. No,
well, if you legally get a divorce and you're still living married, that might cause other problems. Medicaid may say that's fraudulent. They may say that's fraudulent. So then you're running into other issues there as well. But yeah, it's strange that we live in a society that promotes marriage, but then when it comes to Medicaid, it's almost a detriment to be married. They make it, you would think the income limits, the asset limits would be at least double, like if for a married couple, that is for a single person, but it's not. The income limit's about $1,700 for an individual and only about $2,300 for a married couple. And same with the asset limits of $30,000 and $40,000. So it doesn't seem to make much sense, but those are the rules. And at least we have spousal refusal that does provide some kind of option if only one of them wants to apply and the bulk of the income and assets is in the other spouse's name.
But what if they're living together but not married? Do they count as a household?
So no, the good news is in New York, there's no common law marriage. If you're not legally married, you could be living together for 50, 100 years, and you're counted as separate individuals for Medicaid purposes.
Okay, but we don't encourage divorce, okay?
No, we don't. We don't encourage marriage either, but we don't encourage divorce for Medicaid purposes. For Medicaid purposes. Okay, that's pretty much my presentation. If anyone, let me see if there's any other questions on the chat, or if anyone has any other questions, feel free to jump in.
Do you have recommendations to elder care attorneys?
That's what I was going to ask, Ed.
Yes, I do. I work with several elder care attorneys, and based on where the individual is located, where they live, and their particular circumstances, I would recommend one to the individual, and they would be able to assist.
How can I get the recommendation?
I'm going to chime in quickly before you go on to the next question.
Sure.
Once Ed has helped you set up the Medicaid, whether there's a trust or not, at that point, that's when Ed will sort of hand you over to me. We work together, and then I will take you to the next step and help you get the home care, the home health aides. But everything has to start with the Medicaid. At that point, yes. Ed will hand you over to me, and we will take over from there.
Yes, and very important to attend the next presentation, which I believe is next Monday at the same time. Rene will go through all the different options for home care and NHTD and all of the benefits. The whole reason why we're assisting clients to get Medicaid for the most part is so that they can get home health aides, like Rene mentioned.
And then that next week we'll answer Hillary's question. Hillary was asking how many hours of home care you can hope to get. So we're going to address that next week.
Correct.
Okay, how can I get the recommendations of the elder care? Can you send me that?
Yeah, if you want, you could. I think my contact information is on the chat, so you can reach out to me directly, and then we'll discuss your situation. And based on that, I'll give you a recommendation.
Okay. Thank you.
We have 2 more questions in the chat box for you, Ed.
Okay. Well, when is the training for next week? That's for you, Meg. I believe again it's Monday at 12. Monday at 12.
Same time next Monday.
And Meg, if you could give our phone numbers out also, Ed's phone number and my cell number also.
Yeah, I think somebody posted my information in the chat. So
I did. I'll go ahead and place your information in the chat box, Rene.
Between
Okay,
now
but
and
my-
next week, people can definitely call.
Yep, and my extension is 101, just in case anyone needs that. Okay, I see a question here. Does the pool trust get established before the application is submitted? So no, generally we submit the Medicaid application. It typically takes about 4 to 6 weeks for the Medicaid application to be approved. So while the application is in process, that's when we'll set up the pool trust, while the application is being processed. Do we service Staten Island? Yeah. Well, Rene will answer the question whether her agency provides services in Staten Island. I believe they do, but we assist applicants with applying for Medicaid and setting up pool trusts in Staten Island. We service the whole state, in fact.
And we do provide home care in Staten Island. We would discuss what the person's looking for, what language you're looking for, what kind of hours they're looking for. And if we, for some reason, can't, I will certainly hold your hand and help you find someone who can. But we do all the boroughs. We're also licensed in Lower Hudson Valley, Rockland, Westchester. So in the name of my agency, I work for Attending Home Care. So we're a home care agency, but we're also approved to provide this other program called Nursing Home Transition Diversion, which we'll talk about next week. And Madge, you could put my number in the 929-475-3152.
Yes, we currently have it in the chat box right now.
Great.
Okay, great. Okay, this is a great question, Hillary. If the client's assets are listed under their children's name also, can a case be made that the assets are the children's? So the answer is basically no. So a lot of clients, right, let's say the child wants to add their parent just for convenience sake. Medicaid is going to look at that full amount as if it's the client's asset. So, even if there's $50,000 in the bank account, Medicaid's not going to say, oh, $25,000 is the client and 25 is the child's. They're going to say the full 50,000 is the client's, and they're going to be above the Medicaid allowable. So we recommend in that situation to create a new bank account under the child's name and transfer most of the assets directly into the child's name. Or if a child is thinking about adding their parent to a bank account that has significant assets, not to do that, they can add them to an account with a small amount of assets that doesn't put them above the $30,000. But we would not recommend them being jointly on an account that has significant assets, because Medicaid will count that as the client's assets, typically. Okay, I think I saw one more question. Let me just go back a little bit. Okay, do you know the implications are for couples who are informally separated? I have a client who said she signed an affidavit with Medicaid stating that they are informally separated and still sharing an apartment. So this really depends on the county and the caseworker. I've seen situations where it goes both ways. New York City tends to be the most lenient county in New York State. So I've seen where clients will claim that they're separated. It's better if they're not living in the same apartment, but I've seen it where they are living in the same apartment. If they have an affidavit or if they have some kind of proof that they're separated, then Medicaid sometimes will process the application as if, as individuals rather than a married couple. Some of the other counties are more strict, Nassau, Suffolk, for example. I doubt that it would pass muster in those counties. So it really depends on the county, on the caseworker. But generally speaking, if they're separated but still living together, even if they're just separated, informally separated, and not legally separated, technically they're still married, and technically Medicaid will want to process the application as a married couple. But like I said, some counties are more lenient than others. In New York City, I've seen people get away with being separated, even though it's not a legal separation, and Medicaid processing their application as individuals. Them still living together further complicates that. So it's a tricky question, and there's no real clear answer on it, other than it depends on the county and the caseworker.
We
What
have
about when
one more question. We'll go ahead and close out part 1 of our presentation.
Okay, do you want me to?
From Colo, yes.
Yes, you want me to answer that last question? Okay, what about when the spouse earns less than the applicant? Well, if the spouse earns less than the applicant and they feel like it would be beneficial to apply for both of them, then they can apply for Medicaid for both of them, even if the spouse doesn't need services yet. Again, it doesn't hurt to have Medicaid. So in that case, we wouldn't really do a spousal refusal. We would just, have the combined income and then set up the pool trust if need be and do it that way. Even if the spouse is making less than the applicant, it still might put the combined income above the Medicaid allowable. So they still might want to do the spousal refusal, but it's less likely. And again, these are all the different options that we would discuss with the client. See both of their incomes, both of their assets, and see which way is more beneficial to apply, whether it's more beneficial to apply for both of them, or whether it's more beneficial to do the spousal refusal and just apply for both of them. So that's part of the analysis that we do when a client comes to us, as we review all the documents and tell them exactly what needs to be done and what the different options are.
Thank you so much, Ed. Again, Ed is with Stay at Home Solutions and Rene Lowy is with Attending Home Care. I did place the information in the chat box if you would like to reach out to them. I have their numbers and their email addresses in the chat box. Thank you again. Thank you to Philip Howard and all the participants. Our next presentation will be on February 12th, which is a Monday from 12 p.m. to 1 p.m.
Okay, great. Thank you, Medj. Thank you, everyone, for attending. Appreciate it.
Thanks, everybody.
Thank you, Renee. Take care.
I see you. Bye-bye.